Exciting program with some components that are experimental and designed to get you involved, but at the same time we have a blend of some very eminent panelists and some good practice exercises for you. The first panel will be looking at various matters, including practical issues in relation to preparing witnesses and the leading of evidence, and tactical and ethical considerations that relate to such issues. The chairman of the panel is Edwardh Greenspan, QC. As all of you know, a leading defense counsel in Canada. Mr. Greenspan, of course, teaches part-time at Osgoode Hall and is actively involved in all aspects of the criminal law. As well, we are graced with His Honor Judge Borins, a most experienced district court judge who sits in Toronto and has been on the bench since 1975, and as some of you may know, a deputy Supreme Court judge of the Yukon when he wants a little break. Judge Borins spent many years teaching in various aspects of the law, and with a special emphasis on criminal law and evidence. And he, of course, is a co-chairman of this program. We are very fortunate today to have Mr. Justice Martin with us as a panelist. Mr. Justice Martin needs no introduction either, and as all of you know, he's of course one of the most distinguished defense counsel and eminent jurists in Canada. Mr. Justice Martin is busy in a multitude of undertakings, thankfully for the profession, one of which is that he is involved in teaching at the University of Toronto Law School. And on that note, I'll turn the matter over to our first chairman, Mr. Greenspan.
Thank you, Murray. We will be looking in this panel at a number of subjects. We'll be looking at the voir dire, some questions relating to the preparation of witnesses and anticipating evidentiary issues and certain ethical problems. And we'll start with the subject of the voir dire. And I'd like to ask Judge Borins to deal with really three questions. When should a voir dire be held? If a voir dire is held, should witnesses be called, or can the judge rely on a summary of the proposed evidence? And must the jury always be excused during a voir dire to determine the admissibility of evidence? Your Honor.
Thanks, Mr. Chairman. I'm going to be as brief as possible because I hope that most of you at some point will read the paper that I have prepared on the subject. I'll assume for the moment that not too many of you have had the opportunity to read it or to read it carefully. For a long time, I've been of the view that many trials are involved with unnecessary voir dires. And it's obvious that a voir dire that is, strictly speaking, unnecessary takes a lot of time and causes a great deal of expense. I have tried in the paper to approach the subject in this way. One begins with the proposition that only evidence that is relevant is admissible in a trial. When an objection is raised with respect to the admissibility of relevant evidence, the question then becomes, how is the trial judge going to determine whether or not it ought to be admitted? We're familiar with the very classic and special example of a confession in a criminal case, and we know that when objection is taken to it, then the trial judge holds a trial within a trial, the voir dire, in which the Crown has the burden of calling evidence to prove voluntariness. Obviously, in a case like that, it's necessary to have witnesses testify. But the confession situation, I think, illustrates the point that I endeavored to make in the paper. It's really only when the trial judge has to make a preliminary finding of fact which conditions the admissibility of the evidence that a voir dire is, strictly speaking, necessary. In other words, the proponent of the evidence has to establish a fact that conditions the admissibility of the evidence. In the case of the confession, it's the voluntariness, and I just restrict it to voluntariness at the moment. In the case of the dying declaration, which is an example I use in the paper, there are other conditions which have to be established to the satisfaction of the trial judge. The opposing party can, of course, call evidence if he or she likes, and I think we may talk about that a little bit later. But in those situations, it's quite obvious that a voir dire is necessary. I discuss in the paper those circumstances when the voir dire can be held in the presence of the jury, and those when it must be held in the absence of the jury. Obviously, a confession is the classic example of when the voir dire should be held in the absence of the jury, because we don't want the jury to hear the evidence, if indeed the statement is disclosed on the voir dire, for obvious reasons. As you read the paper, you will see that in some situations it could well lie within the discretion of the trial judge as to whether or not the jury should be absent during the voir dire. Another situation where a voir dire is necessary is to determine the competence of witnesses, child witnesses, expert witnesses, and so forth. Once again, the proponent of the witness has to establish certain facts which would condition the evidence or competence of that witness. There, I suggest the voir dire can and should be held in the presence of the jury, because this is important background evidence that the jury should know about if the witness is ruled competent to testify. If the witness doesn't testify, no harm is done. If the witness does testify, then the evidence doesn't have to be repeated again in the presence of the jury had the jury been excluded. I suggest that there are a good many voir dires that are unnecessary in situations where no conditioned precedent has to be established with respect to the admissibility of the evidence, that the admissibility of the evidence can be determined by a statement or summary or stipulation of the evidence made by the proponent. For example, with similar fact evidence, I think that rarely should a voir dire be held, because the proponent of that evidence can give a complete summary of it, and then arguments can be based on that summary and a ruling can be made. I don't know whether I ought to take any more time, Eddie, in dealing with the matter. I've just sort of highlighted the paper. I would point out that there are several authorities in the paper which I rely on in support of the proposition that there are probably too many voir dires conducted unnecessarily.
All right, we'll look very briefly at just some tactical considerations about whether you object, and what are the tactical considerations in whether or not to object to the admission of evidence, to ask for a mistrial where there's prejudicial and inadmissible evidence coming out, and how do you object? How does counsel object to the evidence? In terms of objecting to the evidence, even though we now have 645 subsection 5 where you have voir dires prior to jury selection, the fact remains is there are many questions that come up during the course of the trial that you can't clear away before the jury is selected, and many that you can't anticipate. And if we're talking about jury trials in terms of objecting, I think it's important to try to frame the objection, if the jury is going to have to leave the room, that it's not your fault that this is going to happen. Because if you start doing it too often and you leave that jury with the impression that you don't want any evidence to get in, they may think that you know something that's not very good about your client's case. And so it's important to try to frame that objection in a way where you put the responsibility on the trial judge, that it's the trial judge who would clearly want to, a matter has come up that I know Your Honor would want to hear in the absence of the jury. But never try to take the blame for sending that jury in and out if you can. And the idea of when to object to the admission of evidence, I think lawyers may tend to over-object. There are clearly things that may be strictly inadmissible, hearsay questions, but I think you've got to very seriously consider how prejudicial is it, how seriously prejudicial is it that you're letting a piece of evidence that may be strictly inadmissible get before the jury. Even much less so in terms of a judge alone. I think objecting to the admissibility of evidence in a judge alone, I think you have to be more circumspect with the judge alone, because you're clearly in a different position. With the jury, you may not want them to hear inadmissible evidence, but I think that you've got to decide, and sometimes very quickly, whether this matters or not, whether it really matters. You have to have an eye always on that question of how much does it matter. In terms of asking for a mistrial where prejudicial and inadmissible comes out, I think the rule is different for a judge alone than it is for a jury. A judge alone, I think, not only traditionally can disabuse his or her mind of prejudicial and inadmissible evidence, but I think sometimes if you were to bring an application for a mistrial in front of a judge alone, you could offend a judge alone if by suggesting that he can't disabuse his mind of it. Where maybe a witness for the Crown testifies about what a rotten person your client is, and that he's got a record for perjury, and I had such a case in front of a district court judge recently, and I had to think, do I now want to ask for a mistrial? And I thought it would be insulting to do so, and I didn't. I didn't call my client, and the judge was terrific. But I went through that process of thinking, are you going to say to this judge, you cannot hear it? And I think that's a very, very difficult thing. One thing for sure is you have to have an eye on the Court of Appeal, in the sense that if you don't ask for the mistrial where there's highly prejudicial and inadmissible evidence going in, and you don't object or you don't ask for mistrial, that could really seriously hurt your client on the appeal. It's a factor that trial counsel did not object. And so you want to try to balance it in a way where you do object, ask for the mistrial where you must. And the one thing that I found is that judges are very reluctant to grant mistrials. And I think the further you get into the trial, the more reluctant they are to grant mistrials. And so if you really feel that you've got something that is a mistrial, you better really rant and rave about it, because and make that judge understand that you're really serious about it, because I think in most cases you're not going to get it. And it may be just pro forma that you're asking for the mistrial because you're trying to protect yourself from your client, in the sense that on an appeal your client will be able to argue that point. Lord, do you have any comment on that?
Well, I generally agree. I think it makes a difference who's asking for the mistrial. At one time, the discretion of a trial judge to grant a mistrial was unreviewable. But now, in my view, under the charter, the judge's direction to declare a mistrial is reviewable if the accused is subsequently charged with the same offense. If the trial judge improperly declared a mistrial at the instance of the Crown, for instance, to enable them to locate a missing witness or to bolster their case, that would be quite improper. And in my view, if on a subsequent trial the accused could argue that the principle of double jeopardy had been infringed. As you know, in the United States, the courts do review the propriety of declaring a mistrial, and in some cases where they hold that the mistrial has been improperly declared, will hold that the accused is entitled to plead double jeopardy, that he can't be retried for the offense. So I think different considerations apply when the Crown is applying for the mistrial, and I would think there would be very few cases where a trial judge would declare a mistrial because some evidence had been wrongly admitted that was prejudicial to the Crown. I would think in those cases an admonition from the trial judge to erase that evidence from their mind would be sufficient. With respect to an application for a mistrial by the defense, I think I agree with Mr. Greenspan that it depends when it took place. If it was a serious error and occurred early in the trial, it would perhaps be unwise to complete a long trial with the possibility of a vitiating error hanging over it. But in the closing stages of the trial, I would be rather loath to move for a mistrial if the case was going reasonably well, because you might be depriving the accused of a chance of an acquittal. I recall a case some 30 years ago where during a lengthy voir dire, one of the jurors was walking around the hall and he met a witness, a man whom he knew, who was an accountant with the Interior Securities Commission. And they were in charge of the prosecution. The prosecution was at their instance. And this witness and the juror went over and had a cup of coffee at Bowles across from the old city hall. And Crown Counsel found out about it. He told me, I applied for a mistrial. Former Chief Justice Segal was the presiding judge, and he called both the witness and the juror to the witness box, and they both said that they hadn't discussed the case. And he refused a mistrial on the ground that he didn't want to deprive me of an acquittal. I was pretty skeptical about his reasons, but the jury, after a long deliberation, acquitted the accused. And I was very happy that my motion for a mistrial had not succeeded. So I think it must be something that's overwhelmingly prejudicial if it occurs in the late stages of the trial that would prompt you to move for a mistrial, because the jury may acquit.
What did they talk about over that coffee?
Well, I think there were high school days and things of that. They both firmly denied that they discussed anything about the case. But it couldn't help but hurt the accused, the fact that he knew his old friend was a part of the prosecution team, I think. But since they didn't discuss the case, Chief Justice Gale wisely, he was a very wise judge, by the way, refused the mistrial. I've always been grateful to him. I think my client should.
Lord, how does the Court of Appeal assess the prejudicial effect of inadmissible evidence?
Well, I think you start off with this premise, that the accused is entitled to be tried by a jury properly instructed on admissible evidence. And if inadmissible evidence, which is prejudicial, has been admitted, it is not the function of the Court of Appeal to retry the case and decide upon the guilt of the accused and dismiss the appeal if they think the accused is guilty. Once an error in law has been shown, the onus then shifts to the Crown to show that a reasonable jury, properly instructed, would inevitably or necessarily or without doubt have convicted on the properly admissible evidence. In other words, is the case for the prosecution so overwhelming, is the evidence so cogent that a reasonable jury, properly instructed, would necessarily have convicted even without the inadmissible evidence? If the error has been the exclusion of evidence, in the wrongful exclusion of evidence in favor of the accused, the court will be even more reluctant to apply the proviso and dismiss the appeal on the ground of no substantial wrong or miscarriage of justice. The court will ask itself whether the verdict might have been different if the jury had heard this evidence which was ruled inadmissible, and will be very reluctant to apply the proviso in those cases.
Right, we're going to move on to another area, and this is in the area of preparation of witnesses. And I want to ask Mr. Justice Martin, what are the ethical limits of the preparation of witnesses?
Well, I think the first thing is to remember that you must not, and I emphasize must not, implant or insinuate into the mind of the witness the version that you would like him to tell. that is completely unethical. But you may, bearing that in mind, probe the memory of the witness by asking him questions which do not lead to implanting in his mind what he thinks you would like him to say. And you know, there's a very good example of that in Louis Kniser's book, My Day in Court. It's referred to in the continuing education program of the Law Society in 1969, the preparation of a criminal case. Mr. Kniser was retained by Mr. Bercovici to sue Charles Chaplin, who Mr. Bercovici claimed had stolen his idea for a film. And Chaplin had gone on and made this film, was called The Great Dictator, and had, of course, cut Mr. Bercovici out of the profits. And Mr. Kniser was trying to elicit information from the witness, Mr. Bercovici, as to whether anybody might be able to support his story. And he asked, had scriptwriters been hired? No, we hadn't got that far. Had casting begun? No, we hadn't got that far. And then finally he remembered that he and Mr. Chaplin had talked to a Russian baritone who Chaplin thought would be very good for this part. And he asked the witness the name of the Russian baritone. He didn't know. Where did the Russian baritone live? He didn't know. What did he look like? That he could tell him. So Mr. Kniser called the Russian tea house, a very logical place to call, and they said yes, they thought they knew who he was talking about. The man was expected in shortly, and within a couple of hours, Mr. Kniser was examining this witness in his own living room. Now that's the kind of probing that's quite permissible, as long as you don't insinuate into the mind of the witness what you want him to say. And you want me to talk about, go beyond the ethical proprieties and the question of what you may do by preparing a witness. I always believed in taking a statement from the witness in an orderly way, and that way I could see whether there were any inconsistencies or improbabilities in his story, and ask him for an explanation. And sometimes he might have an explanation, sometimes he might not, and I might decide not to call. But if he has an explanation for those improbabilities or those inconsistencies, it's better that you ascertain them and to see whether he can account for them. You know, a witness may go in the witness box. He may give some wonderful evidence for the defense. And then you're devastated when a police officer goes into the witness box in reply and says he spoke to the witness and the witness told him he didn't know anything about it. Now, that is your fault for not exploring with the witness whether or not he has discussed the matter with anybody else. And sometimes if you ask a witness, have you given a statement to anybody else? He will say no. What he means is he hasn't given a written formal statement. He thinks that mere discussion with somebody didn't constitute making a statement. So you should explore with him whether he has any previous discussions about the case. And if he has, did he tell the same story? And if not, why not? Well, maybe he has an explanation. Maybe he was threatened. He was afraid to tell the true story, or maybe he just didn't want to become involved. That's not as good an explanation, but it may be an explanation. But you are entitled to tell the witness what is expected of him, how to give his evidence. Some witnesses, seem to be incapable of replying to a question. They want to make a speech. I remember I was defending a man many years ago charged with murdering his wife. And he had a very good partial defense of intoxication, although the feeling in the community was very much against him. And I went out to the jail to see him, and the first question I asked him, did you love your wife? And he said, well, not as much as my first wife. And, that's not a very helpful answer when you're charged with murdering wife number 2. And so I tried him again, and I said, did you intend to kill your wife? And he looked at me as though I'd taken leave of my senses. And he said, of course not. Where would I ever find anybody to do the amount of work she did for nothing? Well, there was a certain amount of cold-blooded logic in what he said. But I didn't think it was going to endear him with the jury, and I didn't call that man as a witness, although I would have liked to. Other witnesses, you can instruct them that they are not to make speeches, they are to answer the questions in a responsive way, and that is perfectly permissible. Some very good witnesses I've had who started out as being not very good witnesses who want to make long speeches that weren't very impressive. You have to tell the witness that that is not his function. He's to tell what he knows, and he's to be responsive to the questions. I don't think you should make it clear to the witness that while he's to tell his story and answer the questions and give it a coherent way, in orderly fashion, you tell it in his own words. You don't want to go over the story with a witness so often that when he gets in the witness box, he appears to be telling it by rote, or this man with a grade 4 education is giving evidence like an Oxford professor. So you make it clear to him that the story is his. You are simply telling him how to give evidence in court. And by the way, there's a good deal that you can do by preparing yourself to ask the right questions, to elicit the right responses. If you're fumbling around, you can't think of the right way to formulate your question so it will evoke an appropriate response, or the response you want, this uncertainty will communicate itself to the witness, and he'll become unsure of what you want from him. So you should approach the witness with assurance. You can only do that by thinking about what you want to ask him. And it's a terrible thing if you ask a question, then have to withdraw it because you know it's leading, it's going to be objected to, it's going to introduce inadmissible evidence, and then the witness says, well, if this lawyer doesn't know what he wants, how am I supposed to know? And you've got not a very good witness after that. So you have to prepare yourself as well as informing the witness of what his role in the court will be.
Answer this, my lord, on a very special problem, and that is the defense of alibi. You have an accused person who comes into your office and parades in 4 witnesses who are prepared to state that he was 200 miles away with them having dinner somewhere. Do you see those 4 witnesses together as a group and hear their story? Do you see them separately and question them very closely? How do you go about, or do you have any responsibility to try to determine or to try to shake or determine the truthfulness of the alibi?
Yes, I think you do. First of all, I would see them separately. So there's no question of all the witnesses being seen together and all knowing what the other one has said and simply confirming it. And I think you have an obligation to, and as best you can, to ascertain whether the evidence is truthful. Because if an alibi is called, and if it is shown by the prosecution to be false, it will have a devastating effect. The jury may jump to the conclusion that the accused is guilty. I found that alibi witnesses usually fix a date by reference to something like a birth certificate, or at least a birthday. They will say that it was their birthday or their mother's birthday, and that's why they remember the date. I used to always get the birth certificate of the person involved. I thought it would be devastating if the Crown were able to prove that the event they're talking about occurred, the birthday was the day before or the day after this event they're talking about. So I would actually go and look at the birth certificate to make sure that at least that was right. And usually if a witness is being truthful, there's some other evidence that can be found that will tend to support him. A bill, a date on a bill, an airplane ticket, a hotel register, something that will tend to confirm his story of the relevant date. Now, I called very few alibi witnesses in my lifetime at the bar. I think because often the alibi tended to disintegrate in my office under close questioning. But occasionally they turn out to be true, but when they are, you can usually find some supporting material that will confirm the story of the witness. I don't want to be too anecdotal, but this may be worth telling. You can read about it in the Advocate Society's journal of a couple of years ago. Many years ago, there was a man named Bohosic who was charged along with Evelyn Dick with the murder of her husband. And Bohosic had been a friend, boyfriend of Mrs. Dick. And when he was arrested, he told the police where he was. That the date of the murder could be fixed as March the 9th. And Bohosic told the police where he was. And it was pretty well the story that he told, except he had mixed up 2 days. He had melded them together, which was understandable. And he said he'd been down at a hotel in Burlington with 2 well-known Hamilton athletes and a couple of young ladies. And I spoke to the 2 men. They were respectable people. And they remembered the incident, but for the life of them, they couldn't fix the date, whether it was March the 9th or March the 15th or what day it was. So then I interviewed the 2 women. The one woman said yes, she remembered the incident, but again, she couldn't remember the date. Where was the other woman? Well, she was living in a rural route down near London. And my colleague, the late Henry Shriver, and I drove down and talked to this woman, and she, like all the others, remembered the incident, couldn't remember the date. And then just as we were about to leave, she said, I think I may be able to help you. I took delivery of a new suit that day, and whatever day I took delivery of that suit, that's the day. She went in the house, came back with a bill for a suit. It was March the 9th. That fixed the day. We now have 4 respectable witnesses whose evidence is unimpeachable. We have the date actually fixed for this bill. I took the precaution of going to the store where she bought the suit and confirming with the store records that that's the date that she took delivery, not relying just on the bill that she produced. So be alert to endeavor to support, if you can, the evidence of the alibi witnesses with reference to extraneous matters.
Question of special considerations or ethical limits where the witness is the accused. And I don't think that ethically there's really any difference in terms of preparation of witnesses other than the accused, different than the accused, other than from a practical point of view, it is more likely that from the accused you're going to get the question, what do you want me to say, when you're talking to the accused. And I think that you as counsel have to be very careful to make sure that you tell the accused that what you want is the truth. From maybe, but that's what you have to say. I think you cannot do anything more than that. There's going to be a greater risk that you're coaching the accused. And that's why you have to be all that more careful of what you're asking and making sure that the accused knows what you expect from him. And I think you have to be really, really careful about it. I don't like, and I actually think it's quite wrong, the anatomy of a murder example where the defense counsel sits there before he asks the accused any question and says, these are all the possible defenses, and then a light bulb goes off in the accused because he likes irresistible impulse or whatever. And I don't think that you should say to any accused, here are the defenses, now let's hear what your story is. The concern is always that the accused will shape that story to fit the defense rather than giving the truth. And I think you as counsel have to make it very clear that what you want from that accused is the truth and nothing more, nothing less. The question, and I wanted to ask Judge Borins a question going back to the voir dire, since we're on the accused and I forgot to ask it, is the business of calling an accused on the voir dire. And I don't want to leave this panel without asking Judge Borins to comment on whether or not you should call the accused in a voir dire.
So, Eddie, maybe I'll combine that with whether you should call the accused at the trial itself. Let me just make an observation or two with respect to the trial and then return to the voir dire. The one question that is often in the mind of a trial judge when the Crown says case for the Crown is closed is whether there's going to be a defense, and if there's going to be a defense, whether or not defense counsel will call the defendant to testify. I've often wondered, and I know a lot of my colleagues have as well, why the defendant has been called in many cases. My general observation is that it is unnecessary to call the defendant as often as I have experienced the accused testifying. I know it's been said, and perhaps you or Justice Martin will comment on this in a moment, that there are many cases where the jury is just waiting to hear the explanation, and absent some explanation, there will be a conviction for sure. I'm not too sure that that's the case. It certainly isn't from my perspective. It may be that defense counsel are having difficulty in determining who is running the trial, which explains why the accused testifies as often as he or she does. Or it may be, and I think this is important, that defense counsel have really forgotten about what a valuable asset the concept of reasonable doubt is for the defense. A properly and carefully analyzed assessment of the case for the Crown, and more so, of course, in a jury trial, will enable defense counsel to logically implant in the mind of the jurors the concept of reasonable doubt. In fact, I once heard Mr. Justice Martin, when he wasn't Mr. Justice Martin, make a very eloquent address to the jury by taking each of the main points in the Crown's case, marshaling the evidence which the Crown had, and as he finished each point, he would look at the members of the jury and say, "Now, members of the jury, doesn't that raise a reasonable doubt in your mind?" I just don't hear counsel approach the case for the defense in that way. And there seems to be some thought that you've always got to call the defendant, and I've heard so many good cases for the defense go down the drain when the defendant has bolstered and strengthened the case for the Crown. So I think you should give very careful thought before the defendant testifies. And I say that as well with respect to the voir dire. And I'm talking about confessions at the moment. There are far too many instances where a defendant gives evidence on the voir dire quite unnecessarily. One of the areas which seems to be covered most frequently is whether the defendant said what the Crown alleges he or she said, or whether it was said as the Crown alleges. Now, I think that calling evidence on that point arises from a misconception of the role of the trial judge on the voir dire and the burden of the Crown on the voir dire. The Crown only has to establish a prima facie case that the statement was made. And all the evidence that the defendant may adduce as to the absence of a statement or the misreporting of a statement is not going to result in the statement being excluded on that ground alone. As far as other factors are concerned, beatings and things like that, that usually doesn't result in the exclusion of the evidence. Usually it implants a view of the defendant in the mind of the trial judge, which may not be the view that defense counsel wants to implant. Perhaps the voir dire with respect to charter matters, where there's burden on the defendant to establish a charter infringement or violation, is another matter, because that may be the only way, for example, to establish a Section 10b violation. That, Mr. Chairman, I think may be a different case.
Laurie, do you have any comment on
Well, I agree with Judge Borins. I think you have to be very cautious about calling an accused. You have to consider what advantages you will get, what disadvantages there may be in calling him. Certainly, I think too often an accused is called on a voir dire as to the admissibility of a confession. I don't recall in 35 years of practice in the field of criminal law ever calling an accused on a voir dire as to the admissibility of a confession. There are two schools of thought about calling the accused as a witness. The one school is do not call the accused unless there's some very strong reason why you should call him. There's another school that says, yes, you should call the accused unless there's some very strong reason why you shouldn't call him. I was a member of the second school. I believed if a witness told you that he was innocent, and he had an accused told you that he was innocent, and he had an explanation to offer, that generally speaking, it was advisable to call him. There were exceptions to that in the case of witnesses who were not absolutely essential, who were likely to make a poor impression on the jury, and in that case, I didn't call the accused. But basically, I believe that if the accused, first of all, said he didn't do it, or if he had an explanation negativing the requisite mental element, that he should have the opportunity of telling that to a jury. And I think I called more accused in murder cases than was the opposite, where I didn't call. And of course, murder was capital in those days. It was a tremendous strain when your client was in the witness box, and if he was convicted, he was going to be hanged, especially if the late Henry Bull was cross-examined. I used to sit there on the edge of my chair and say, my God, I wonder if the accused has told me everything. Mr. Bull knows something that I don't know. And but I used to call them, and generally I was satisfactory results. But you have to be careful, and don't just obey the instructions of your client always without reasoning with him. After all, you're there to give him professional advice. You're not there to be an errand boy just to do what he tells you to do. You're supposed to exercise your professional judgment. Of course, if he insists on going into the witness box, you can't prevent him. You can't grab him by the neck and pull him back. But you can give him very, very strong advice. In the Linton murder case, the accused at the first trial alienated the jury by telling a story that alienated the jury against him. And I went down for the second trial, and he proceeded to tell me what he was going to say in the witness box. And I said, oh, by the way, you're not giving evidence. I said, you ran the first trial and you saw what happened. And so if you're not going to follow my instructions, I better go home. And we didn't call the accused, and we got a good result. And that was a case of a lawyer just doing what the accused told him, not exercising his own judgment and arguing with the accused that the worst thing for him to do would be to go in the witness box.
To move then to briefly to a topic of anticipating evidentiary issues. How do you prepare to meet evidentiary issues that you anticipate will be raised at trial? Well, this may sound simplistic, but reading the Crown brief can be very helpful in preparing for a trial. Looking at the preliminary hearing and actually reviewing it can also be a very helpful guide in trying to identify evidentiary issues. Hearsay questions, one big category, relevancy questions. Then you can research it before you get to the trial and be ready. You can anticipate a lot of these questions, and I think now with 645 subsection 5 of the Criminal Code, where we have these voir dires before trial, you're focusing in more on these questions. With the pretrial conference, most particularly, you're forced now to look at the case long before the case comes up, and not just the night before. You sit down with the judge, and people want to know what the issues are. But I think it's very important trying to prepare to meet these issues and have your case law ready long before trial, so that no one can anticipate every conceivable evidentiary issue that will come up. But many of them are easily ascertainable by simply reviewing the material carefully. And coming to the question that I want to ask Judge Borins is, as a trial judge, what kind of material do you like to get if you're dealing with an evidentiary issue? Counsel raises an evidentiary issue. What would you like to have from that lawyer?
I would like to have a brief of authorities, 2 or 3 relevant authorities, and any authorities which might help the other side, because I feel that counsel has an obligation to bring to the court's attention authorities on both sides of the issue. With the device of Section 645 and with the other device of compulsory pre-trials in virtually all criminal cases, counsel should have no difficulty in detecting in advance at least the major evidentiary problems that might arise. Certainly in any lengthy trial that I conduct, and I define that by being more than 4 or 5 days, I always meet with counsel beforehand, regardless of whether there's been a pre-trial review with some other judge, to conduct what I call a management review of the case. And one of the important things that I want to know about is the evidentiary issues that I might meet along the way. And I'll make it pretty clear to counsel that I expect of them that they will furnish me with the authorities, certainly sometime before the issue is raised by way of voir dire or by way of objection. And I also tell them that if there are any other issues that come to mind during the course of the trial, that they should discuss the issues between or among themselves, and not blunder into a situation where the evidence might inadvertently be disclosed to the jury. In other words, I feel that counsel does have an obligation to alert other counsel and to alert the court that there is going to be a problem with the evidence. And as Mr. Greenspan mentioned earlier today, this can be very quietly done at the appropriate time by saying there's an issue that we ought to discuss in the absence of the jury. The bottom line is I like to see counsel alert one another of the issues, alert the court of the issues, and be prepared with the relevant material. And I also think it's a very good idea for counsel to have a text on evidence, if they don't develop their own case book on it, to always carry to court so that it's readily available and they don't have to send down to the library.
Lord, I want to ask you a question on this business of providing judges with authority. You're a defense counsel, and you're acting on behalf of an accused, and there's an evidentiary issue that's coming up. Your opponent, the Crown Attorney, is one of those rare Crown Attorneys that's totally unprepared and knows no law. You have two authorities that are very, very helpful to your side. They're district court, single judge of the Supreme Court in Ontario, and there's this British Columbia Court of Appeal case that's dead against you. Do you have any obligation as counsel to provide the court with the authority that is going to probably be persuasive to that judge? It's not binding, but it may hurt your client's cause at that stage.
And I think it's an ethical duty to supply the judge not only with the cases in your favor, but any cases of which you are aware that are against you. And while you may lose the trial, you may not. The judge may not be persuaded that the decision of the Western Court of Appeal is correct, and he may prefer the decisions of the district court judge that you have referred to. He's not bound to follow the Court of Appeal of another province, although it will have great persuasive authority. But if your client is convicted and you appeal, you will have the opportunity of persuading the Court of Appeal that they should not follow the Court of Appeal of a sister province, and you will also have shown that you were the one who referred the judge to that authority. So I don't think there's any question at all. It's unfortunate, but that's the price you pay for reading your law diligently. If you come across a case that's against you, you have to give that to the court.
So to be an effective counsel, you shouldn't read law.
I didn't say that, you said it.
The last question in this area that I want to ask you is what is the obligation? And Judge Borins commented on it, but what is the obligation to tell the other side well in advance that there's going to be a particular issue, so that opposing counsel can have lots of time to prepare to meet the evidentiary issue? Do you have that obligation, or can you, as a defense counsel, walk in and surprise the Crown with an evidentiary issue that they just won't be prepared for?
Well, I would prefer to give the Crown ample opportunity to look into the matter. If your submission is invalid, it's not going to be sustained eventually, likely, and therefore I think you really, while it may sound as though you're helping the other side, you're really only performing your ethical duty, and I think it's desirable that you notify the opposing counsel so that the court will have the benefit of full and informed argument on this particular topic. Not all cases end at the trial level.
And if you don't, you'll likely get the opportunity to take a little rest while your opposing party is granted an adjournment to prepare to meet the point that you should have informed him or her about some days before.
Lord, Mr. Justice Martin, I want to ask you about what you do. You have a witness on the stand who commits an unanticipated perjury in the course of his or her testimony. What is the counsel's responsibility? What can the judge do if counsel shifts the problem to him? And are the considerations different if the witness is the accused?
Well, that's a very difficult question. I think the question is, when it is phrased in the form of the witness who commits unanticipated perjury, means what happens when the witness tells a story that's different to the one he told you. I think that you have to assume that what he's now saying under oath is the truth, and that what he told you not under oath is not the truth. And you do nothing about it. Certainly you don't go to the judge and say, I think my client has just committed perjury, I'd like to be withdraw from the case, or you don't tell the Crown Attorney, I think my client has committed perjury, go after him on that point. I think there's nothing you can do. If the client tells or a witness tells a story that's different to what he told you, I don't think you can assume that he's committed perjury. That is for somebody else. But in any event, I think your obligation as counsel precludes you from going to the court and revealing what the witness had previously told you. You just carry on. You may not rely on that piece of evidence if you think it's untrue in your summation to the jury or your argument to the judge, but I don't think you can reveal what you have learned during privileged communication. Yeah?
I agree. I was going to ask Mr. Justice Martin if he thought that counsel at that point should just fold his or her book and walk out of the courtroom, or could do that.
Well, I don't think he can do that. I think he has to stay and do the best he can with this unexpected turn of events. He may exercise some judgment on how much he relies on this unanticipated evidence, but it's well known that, and I think it's been held by high authority, that a lawyer would be wrong to get up and walk out of court and abandon his client.
What would happen if, at a break, they had a discussion, and when court resumed, the defendant said that I'm firing my lawyer?
Well, again, you have a very difficult question. The judge, if he thinks it's just a ploy to get an adjournment, may refuse. He may require the accused to go on without counsel. That is, if he thinks it's a ploy or if it's made for an improper purpose. And he may let the lawyer withdraw. In fact, he can't impose the lawyer on the client against the client's wishes, but he may say, I refuse to grant you an adjournment. You'll have to go on and defend yourself if you want to discharge your lawyer. He will only likely do that if he thinks that it's a ploy, that he's discharging the lawyer to get an adjournment or something of that kind. It's a very difficult question. But certainly if the lawyer is fired, he can't continue to act, and he can't impose his services on the client, or the court can't impose his services on the client who doesn't want them. Don't you agree, Mr. Fletcher?
I agree, but I think that if the lawyer were to try to use that avenue as the way of getting out of a difficult situation, that he's doing something that's quite wrong at that point. If he tries to get himself fired because he doesn't like what's happening, at that point, he's indirectly signaling to that trial judge exactly what the trial judge probably knows anyway, that the accused is lying. But I don't think that counsel can in any way do anything that would assist the court in coming to that conclusion. I think that would be I think it'd be fundamentally wrong to try to use that route of going out to your client saying, you're firing me because I can't stomach this.
Oh, I agree, but I had assumed from the question that the lawyer had actually been fired by the client, not that this was a scheme worked out between the two of them so the lawyer could get out of the case. And if the client actually has discharged the lawyer and it's not a ploy, then I don't think that the lawyer can force himself on the client, or the judge can force him on the client.
I certainly agree that the judge can't force the lawyer on the client, but the very difficult situation, I think, is when the judge can't really determine whether this was a ploy or whether this was a genuine firing, and of course you can't put either of them in the witness box and ask them questions about it. That's the difficult situation.
Just briefly, before we finish, look at one more question, and this is the ethical limits in cross-examination of witnesses. When is it proper to attack the character of a Crown witness? The Bar Council in England says that you cannot attack the character of a witness if it is not part of your case. And I think that is really an accurate statement of what counsel ought to be doing. In other words, you should not merely attack a witness called by the Crown to please your client, because your client wants to see you cross-examine someone on their character. It has to really form part of your case, and I think you as counsel have to make the decision as to how far you're going to go in the cross-examination of character. The client can never dictate to you what you can and what you cannot do, what you should and what you should not do, or how far you're going to go. The other question is I'll ask Judge Borins this, is what kind of power does the trial judge have to limit cross-examination?
Well, because of the shortage of time, I'm going to give you a short answer. Considerable. I endeavored to address the problem a long time ago in a case that is reported, a ruling that is reported, which may have a familiar name to some of you. It's called R versus Robotham number 5. And this is reported in 1977, 2 Criminal Reports, 3rd series at 293. It's the self-same Robotham who was the subject of a judgment recently in the Court of Appeal, which Mr. Justice Martin was one of the authors. In fact, this man probably will set the Guinness Book of Records, the record for the Canadian who has been involved in the most reported judgments and rulings in history. But in any event, this was his first drug trial, and after 3 or 4 months of being inundated by what I felt was unnecessary cross-examination, the issue was presented with respect to the very point that Mr. Greenspan was discussing, the scope of the cross-examination of a particular RCMP witness concerning his credibility or his character. And I have been patiently working my way through McCormick on evidence of this trial as some sort of perverse relief. And I had just sort of come to that part of the book that dealt with the subject, so I took advantage of the situation more to educate defense counsel than anything else, I suppose, to endeavor to set out the the boundaries of proper cross-examination, which I submit are governed as well by the principle of relevancy, just as examination in chief is, and I deal with the discretion of the trial judge to place limits upon improper cross-examination, and it's all there if anybody wants to read it, Mr. Chairman.
I thought Robotham would make the Guinness Book of Records for spending more time in jail for a little hash and grass than anyone in history.
I tried, but the Court of Appeal didn't agree with me. He'd live to see another day. He stopped sending me Christmas cards, though.
The last question that I just want to briefly look at is the limits on cross-examination where the client has admitted his or her guilt. And this, although everybody views this as a really tough question, I think that the professional rules of conduct answer this question extraordinarily well. In Rule 10, Commentary 11. And that, I mean, people have all kinds of moral problems and hang-ups about walking into a case where your client has clearly admitted guilt. And this rule sets out and circumscribes exactly what you as counsel can or cannot do. If the client clearly admits to the lawyer the factual and mental elements necessary to constitute the offense, and the lawyer is convinced that the admissions are true and voluntary, can take objection to the jurisdiction of the court, to the form of the indictment, to the admissibility or sufficiency of the evidence, cannot suggest that some other person committed the offense, or call evidence by reasons of the admissions the lawyer believes to be false. Nor can the lawyer set up an affirmative defense that is inconsistent with those admissions, like calling an alibi, intending to show that the accused couldn't have done it or in fact had not done it. But the one thing is very, very clear, that the lawyer is entitled to test the evidence given by each individual witness for the prosecution and argue that the evidence taken as a whole is insufficient to amount to proof that the accused is guilty of the offense charged. But the lawyer should go no further than that. In other words, if your client tells you that he did the robbery, you can walk into court, plead not guilty, and cross-examine the identification witnesses on the basis that that evidence is not trustworthy in terms of their ability to observe to the trier of fact. I see no problem with that at all, and that rule, I think, clearly sets that up. It's now 10:20. I'd like to thank you very much, Lord. It's always a pleasure to listen to you, and to you, Judge Borins, again, thank you very much, and a pleasure to have you here as well. Thank you.
Okay, I know that the lunch break was not very long, and some seminars ran late. But if we don't get started now, we're going to run even later. So what I'll do is I'll start, and I'm sure there'll be people coming in from time to time. Let me just introduce the panel. I'm Marc Rosenberg. To my right is Nola Garton, who I think most of you know, practices criminal law, defense law in Toronto, and has been a criminal lawyer for 14 years. To my immediate left, of course, is Earl Levy. Everyone knows as the one of the leading criminal defense lawyers, and of course the president of the Criminal Lawyers Association. And then to my far left, Murray Segal, who is now holds the title of Deputy Director of the Crown Law Office at 18 King Street. And perhaps just with those very brief introductions, I'll go right to the subject of this panel, which is recent developments in the law of evidence. We will, of course, touch on some tactical decisions and some practical points, And I think it's fair to say in the last couple of years there's been some rather important changes to the common law as a result of the Charter of Rights in particular, and in addition some important statutory amendments that we'll try and discuss. Nola, let me start with you and pose this question to you. Assume you have a client charged with sexual assault and his only criminal record is for a similar offense, sexual assault, perhaps a few years ago or even further, many years ago. As a result of the decision of the Supreme Court of Canada in Corbett, it's the way I read it anyways, there's now a discretion in a trial judge to prevent the Crown from cross-examining the accused on his prior criminal record, notwithstanding Section 12 of the Canada Evidence Act. And what I want to ask you, Nola, I guess, is in what circumstances can you call on the trial judge, or in what circumstances would the Crown be prevented from cross-examining on that criminal record?
Well, Corbett discusses a number of factors that a trial judge would have to take into consideration when you've got your accused on the stand and are trying to prevent the Crown from cross-examining him on his record. I think it appears to be, you start from the point of view that it's basically an inclusionary policy. That is, the Chief Justice Dixon in Corbett says that if in doubt, you're better to err on the side of including the record as opposed to excluding it. But there are a number of factors, and he defers to Mr. Justice Laforêt, who came to a different decision in his dissent, but did outline some useful factors for the court to take into account. I guess the first is the nature of the conviction. And if you're in a situation where the client's only conviction is a sexual assault, you could put to the trial judge, well, really, how probative is this in terms of his credibility? After all, that's what the criminal record is being used potentially by the Crown to cross-examine your client on, is his credibility. And the fact that he's been convicted of assault or sexual assault, it may show that he's of combative nature, perhaps, but really does it go to his credibility, as opposed to a previous conviction for theft or something like fraud, which shows perhaps the dishonest nature and is more probative in terms of the credibility issue. Mr. Justice Laforêt also talks about the fact that one should be very careful about admitting before a jury a record which is very similar to the one which the accused is facing trial on now. And in fact quotes from an American case, Garton, which is in the materials, saying that really the admission should be used very sparingly when the record is similar to the one that the accused is being tried for at that time. This is because of the very stringent law that is applied in similar fact cases. Why should we be any less cautious in terms of admitting similar fact of a similar conviction? The remoteness or nearness of the previous conviction is also another factor. If he was convicted of sexual assault some 20 years ago and has led a blameless life, why should, in 20 years and now faces another charge, it becomes very prejudicial because it resurrects that other charge and may make it more important, and the jury is more prone perhaps to use it for finding he's a bad character and more likely to have committed the offense in those situations. I guess that the determinative factor, the one that was determinative in Corbett, really hinged on how you as defense counsel approached the case. If you have strongly attacked the credibility of the Crown witnesses in the case, brought out their criminal records and really gone after them, then I think you'll have great difficulty in keeping your client's criminal record out. This seemed to be what tipped the scales in terms of at least Chief Justice Dixon's mind. He wrote the majority judgment, letting in the Corbett case 1972 or 3 conviction for non-capital murder at the accused's trial for murder. He held that even though one could argue that that wasn't really probative of credibility and was a tremendous prejudicial effect, the whole tactic of the defense at trial had been to bring out the records of the Crown witnesses and discredit them. And he was very concerned about creating an imbalance in the mind of the jury, that you were presenting your client as this lily white character and the Crown witnesses were all bad. Mr. Justice Laforet felt that that could have been handled by other means, that is, there was evidence that the accused was a drug dealer and that he wasn't really all that great a character in other areas, and that the balance wasn't tipped enough, but nevertheless the court ruled that the evidence would go in. And that's basically, I think the case says that the trial judge has to make the decision in the context of all of the facts and circumstances as the case is developing, and it'll tend very much to depend on how you handle the case yourself.
Well, then, Earl, let me ask you, what kind of an attack on the credibility or the character of, say, the principal Crown witness is going to trigger the kind of ruling that Corbett was faced with? I mean, there's a guy who, as Nola says, he's convicted of non-capital murder 12 years before, attacks the credibility of the chief Crown witnesses on their criminal record. Is that what it means, that as long as you stay away from the criminal records of the Crown witnesses, you'll be all right?
Gee, I don't know, Mark.
We just discussed this at lunch.
Corbett deals with the issue of credibility strictly in the light of the witness's criminal record. But let's suppose that you have a Crown witness who has led the life of a fraudsman but has never been convicted. I mean, it seems to me that to make a distinction between a fraudsman who has been convicted and a self-admitted fraudsman is a distinction without a difference. So I think that as long as you attack the credibility of the witness, whether it be by way of his criminal record or otherwise, that you're really in danger of opening the door to permit the Crown to cross-examine the accused on his criminal record. Another interesting aspect occurs. Under Corbett, there would be a good argument to keep out the criminal record of an accused that does not relate to credibility. Offenses such as, well, let's suppose that the accused was a prostitute or a gambler or a drug addict. But if you attack the character of the Crown witness, and the Crown witness's character is such that he or she was a prostitute or a drug addict or gambler, would you then not open the door to attack the character, or would the Crown not have the opportunity to attack the character of the accused, because the jury could be left with a distorted view as to the realities of the situation, because obviously counsel's trying to show that the character of the Crown's witnesses are blemished, whereas the character of, or leave the impression that the character of the accused was an unblemished one. Sorry, that the reverse was true with respect to the Crown witnesses. So I think it's you have to keep in mind when you read the case that it's not just something that relates to criminal records, that there are other aspects that could open the door.
Before we move on something else, let me just say I'm not sure that I agree with you at all. I think Corbett was dealing with the problem of Section 12 of the Canada Evidence Act. I don't think... Are you saying that if you attack the credibility of a Crown witness, say that she's a prostitute or she's something else, that therefore the Crown can then lead evidence that your client is a prostitute in cross-examination of your client?
I say that's an issue. I say that's an issue to be very concerned about.
Okay.
Because of the fact that you're leaving the Crown's... I mean, you're going to go to the jury and say that the Crown witness's character is very blemished.
Right.
And you're going to, if you don't say it about your own client, you're going to leave the impression that your client has an unblemished record, and therefore an unblemished character. So accept what my client says, not what the Crown witness says. I think that leaves a distorted view with the jury.
I think you're right.
An unfair view.
I think it does leave a distorted and unfair view. I think, though, that the common law allows you to leave that distorted and unfair view in Davidson and DeRosey. Can you say, Murray?
Yeah, I think what Earl really means at a minimum is that the fact that the defense has jumped all over the bad character, not necessarily the record, but the bad character of the Crown witnesses is a factor that goes into the decision-making process about the admissibility or the right of the Crown to get into the accused record. That's the minimum, but I tend to agree with Marc that unfortunately, at least from the Crown's perspective, Davison and DeRosy means that, in effect, a distorted view can be left on the other issue of leading evidence of bad character, and the Crown is not permitted to do that. But it certainly, the distortion factor can be brought into play in terms of the Crown's ability to lead the record.
I think it should be pointed out that when you get a ruling against you and the Crown is allowed to cross-examine, that he is limited in terms of what he can do too. He can't go behind the conviction. All he can get is the date and the conviction and the particulars of that. He can't go and he can't ask things like, well, was that a case where you were shoplifting again back in 1968? And he can't ask questions that did you take the stand and the jury not believe you that occasion too? So he is limited in terms of what he can do with the record.
Nola, I don't mind being set up here like this, but don't steal my answers that come later on in the program.
All right. Just before we move off Corbett, I just want to raise one practical problem. You're at the end of the Crown's case, and you're trying to make the decision whether or not to call your client. And one of the important issues, obviously, is going to be, will the Crown be allowed to cross-examine the accused on the criminal record? Nola, before you call your client, are you entitled to ask the trial judge for a ruling so that you can decide whether or not you want to call him?
Yes, that was the situation in Corbett. Prior to the accused taking the stand, defense counsel asked for the ruling. And when the ruling went against him, he called his client and he brought out the record himself to soften the blow, as he put it. And then in appeal, the Crown argued that perhaps that prohibited him from appealing on the ruling, and the court said no, that clearly he had put it in issue, and having lost, he decided he would handle it tactically that way, and that it did not affect his appeal.
Well, what if you get this ruling from the trial judge and he says, yes, I'm going to allow the Crown to cross-examine, so if you want to bring it out direct, that's fine with me. And the defense lawyer says, well, in light of your ruling, I'm not going to call my client. You get convicted, your client gets convicted. Are you then entitled to go to the Court of Appeal and say, well, but for that, what I say now is an erroneous ruling, I would have called my client. Can you raise that on the appeal, or
No,
is that it?
I think you're foreclosed in that situation from raising the issue on appeal.
So you'd have to call him, and if he gets convicted, then raise what you say is the erroneous ruling?
Then you could still raise the erroneous ruling the alleged erroneous ruling on appeal.
Let me put a different wrinkle to Murray. It seems to me that if you read Corbett in light of both what Earl and Nola have said, a lot's going to depend on how you conduct the cross-examination of the important Crown witnesses. Before, say you've got the chief Crown witness, he's a thoroughly disreputable character. Are you, and I'll ask Murray, are you entitled to say to the judge, Judge, I want to ask these questions, but if I do that, are you going to let the Crown cross-examine? Because that's going to determine my cross-examination. In other words, are you entitled to that kind of anticipatory ruling?
Well, when you say you, of course, you're referring to the defense counsel, and as a Crown, I'd say that I'd want to have no part of that instinctively. The common law is clear that anticipatory breaches should not be dealt with by the court. It's in the interests of the expediency of court proceedings. And really what's happening is that the defense counsel is asking the judge to help him or her out on the decision to cross-examine Crown witnesses as to record, and it's the defense counsel's decision to make then and there, and not drag the Crown and the judge into it on, and as far as I'm concerned, it's a moot matter. The defense counsel should make up their own decision, and treading in the Crown's portion of the case is I view it as sort of sacred ground. And the anticipatory ruling, the earliest I could see it coming, is at the outset of the defense case, as happened in Corbett. But even in Corbett, it was a constitutional challenge, and there may be some scope to say that the defense should make up their own mind in what to do with the case. That may be a rather extreme position. The Supreme Court of Canada didn't really comment on it, but at a minimum it should stay out of the Crown's case proper for administrative expediency.
Do you agree with that, Earl? Do you think you're not entitled at all to ask the trial judge for some guidance? I mean, this may be the most important ruling you'll ever get out of the judge in the trial.
Well, I mean, there's no doubt one of the most important decisions defense counsel have to come to tactically is whether or not to call his client in a case. Sometimes it's easy, sometimes it's very difficult to make that decision. It'd be great if you could ask the trial judge before you get to cross-examine the Crown witnesses, but my sense is that the trial judge is going to say, well, just a second, you're telling me this now, but I have to see the lay of the land. I have to see how you cross-examine these witnesses. I got to see what the answers are going to be and weigh it all up to come to some sort of informed decision, and I can only do that after the Crown's case is in. I mean, there's been no... I think it's going to have to be thrashed out, and the courts are going to have to decide on the issue. It's a thorny one, but my sense is that you're going to have to wait till after the Crown's case is in before you can ask for anticipatory ruling, because normally they're just not allowed.
Okay. Let's go to another topic, another decision of the Supreme Court of Canada, actually, and that's the recent decision of the court in Moran. Let me ask you, Nola. Moran itself was dealing with the admissibility of psychiatric evidence, in that case on behalf of the Crown, but has the Supreme Court of Canada in that decision modified the old Ray rule, trivial probative value, highly prejudicial, or is there some other balancing test that you can ask the judge to apply now where prejudicial evidence in general is being admitted?
I think there is room to argue that the Ray rule is being expanded to create a broader discretion on the trial judge than was previously accepted. I think you can actually start with Corbett and some comments that were made by Mr. Justice Laforêt in his decision in Corbett, and he criticizes the Ray rule, saying it's not really a test, and he refers to the Morris case, and where Mr. Justice Lemaire says what really was contemplated was more of a balancing of factors. And Mr. Justice Laforêt also talks about the balancing of factors, a test that's used in England. Then you move into the Moran case, and Mr. Justice Sapinka in his ruling refers back to Laforet's judgment in the Corbett case, and also to Mr. Justice Lemaire's case in Morris. And to actually quote him, he says, in considering whether an exception should be made, regard must be had for the underlying rationale of the exclusionary rule. Does the prejudicial effect of the evidence outweigh its probative value? An exception should be made if the scales tip in favor of the probative value. So he's talking more or less about a weighing up one side against the other, as opposed to having to have a case where the evidence is of really trifling probative value and grave prejudicial effect. So we may, in effect, be widening the discretion.
So you might be able to take those kind of three cases, or the whole line of cases, and say, well, the Ray rule is really essentially gone, and you're entitled to take any prejudicial evidence and ask the judge to do this balancing test.
I think you might argue that, because Mr. Justice Sapinka doesn't, in his judgment, even refer to Ray. He just talks about weighing up the evidence in these situations. And I think that you can argue that it might be, whenever there's a discretion, that Ray might be substantially affected.
Okay. Earl, let me just, before we move off Moran, just ask you sort of the narrow point in Moran itself, which had to do with the psychiatric evidence on behalf of the Crown. As we all know, the court in the end held that the evidence was inadmissible. When will psychiatric evidence be admissible for the Crown?
Well, Mr. Justice Sapinka sets it out very succinctly, and I wrote it down, so forgive me if I read, but he says as follows: if it is relevant to an issue in the case other than to show propensity, if it is relevant to another issue, such as identity, then it must be determined whether its probative value outweighs its prejudicial value on the propensity issue. If its primary relevance is to show disposition, then the evidence must be excluded. Now, with respect to the issue of identity, which was the key issue in Moran, he said as follows: the evidence must tend to show that the accused shared a distinctive, unusual behavioral trait with the perpetrator of the crime. The trait must be sufficiently distinctive that it operates virtually as a badge or mark identifying the perpetrator. So in Moran, the accused was found to be only a simple schizophrenic, and there was no evidence that he had the tendencies to commit to this rather unusual, abnormal crime. Is that right, Marla?
Murray?
Was Marlys there, Chief? Did I get it right, Marlys?
Murray, maybe I'll ask you a comment, and I must say, how do you ever determine that? What kind of evidence would you ever call to show?
I haven't. I mean, upon reading more, and I can't really say that I have any clear idea of what special evidence could be called. But I just want to make a comment about what Nola said, and I think what you adopted about Ray, and which I think is a sort of a major issue, and that is, I don't view these decisions at all as any major inroad into Ray. It can't be forgotten that in Moran, the comment that Nola referred to wasn't necessary for the decision because the evidence was not probative. It wasn't relevant to identity, and all the case deals with is psychiatric evidence in any event. And one would have thought that with respect to the possible overruling of such an important principle, that there would have been some considered opinion, and that the matter would be vetted. Although, to use the emerging wording, which perhaps is imported from charter tests, on balance, I'm a little concerned with the inroads that those comments import.
Okay, maybe we'll move on to something else, except just to reply to you, maybe what the court is saying is that it's contrary to fundamental justice, Section 7 or 11B, to let in evidence whose prejudicial value simply outweighs its probative, or prejudicial effect simply outweighs its probative value, period. I don't know. Let's move on to some of the statutory changes, and maybe for this part of the panel, if you want to look at the sections we're going to be discussing, if you turn to Chapter I in your materials, and particularly I-15, you'll see set out there is Section 643.1. I hope. Yes. I-15, and Murray, let me ask you, this new provision which permits the admission of a videotape of a complaint by a victim who is under the age of 18. If you read the section, it says that the evidence or the videotape is admissible if the complainant, quote, in the last line of the section, adopts the contents of the videotape while testifying. I appreciate there hasn't obviously been very much case on this, but in your view, what does this mean, adopts, and how does the Crown, when will the Crown be able to get this evidence in?
Well, traditionally adopt, at least in the sense of prior inconsistent statements, means that agreeing that something was made and that the account is true. The question really touches on the issue as to what discretion does the trial judge have to to admit or exclude, or put another way, what are the conditions precedent to admissibility? And I can see difficulties emerging in terms of the word adoption, having in mind that it would not be uncommon for a youthful complainant to give either a vague or incomplete description of the events on the tape and then go on to expand in detail in testimony viva voce, which may lead to a partial or a qualified adoption, supplemented by what comes in the viva voce evidence. And the question is partial or qualified adoption adoption in the sense that it is used in this particular section? And another point which sort of relates to adoption, I think, would be the words describes the acts complained of. The videotape has to have that particular condition satisfied. And what happens, again, as I've touched on, in circumstances where the account is vague, having in mind the uncertainty as to who is going to be conducting these videotapes. It's not clear, at least to me, whether one envisions, for example, a police officer or a social worker or both, or a crown, working with these videotapes. And the consequence of perhaps someone not legally trained is that you may have a circumstance where the tape contains leading questions and less than weighty answers. And in that case, is there a description of the events on the tape which the witness is adopting or can adopt? Now, I suppose it must be remembered that while the law is new and untested, the general theory is that this particular technique will permit a complainant, youthful complainant, to give a candid account with all that that entails, including and perhaps an emotional outpouring, and that the defense are going to be leery of this technology. As a matter of fact, we're going to get onto it in a second, but I had a defense counsel's bad dream last night, and that was that there was a videotape made. A videotape made of the complaint. No, the check didn't bounce, Earl. A videotape made, and then, as we'll discuss in a minute, the trial judge permitted the rest of the evidence, including the adoption, to be done behind a screen, so that, and if you wanted to really make it go one step further, all this happened at a preliminary, and the evidence was read in under old section 643, so you could have an entire trial which would be about 2 steps removed from reality. So there are a lot of things here that are uncertain, and the words adoption and description of the events, just fastening on the statutory language, would be an important foothold for the defense to wrestle with when faced with this new technology.
What if the videotape is somewhat unsatisfactory from the Crown's point of view, and that it's not quite the story that the witness is now prepared to give, and maybe I'll ask Earl, as defense counsel, are you entitled to, number one, access to that tape, and number two, are you entitled to lead it? Are you entitled to cross-examine on the tape? Do you play the tape? What do you think?
Well, I think you're very clearly entitled to access to it. I think it should be treated as a statement by the witness, and your access to it may depend on the rules of disclosure. You may not be able to get it before the preliminary hearing unless the witness somehow refreshes his or her memory from the tape, and you may have to wait to trial, although I would argue this is such a departure from the ordinary rules of evidence of this procedure that you should be entitled to it at the the earliest opportunity, and I have the feeling that defense counsel will probably be able to have access to it early. It can be used to contradict the witness, maybe refresh the witness's memory, to coax the witness. You may want us to view it to see whether or not the witness was influenced. As Murray said, you want to see the demeanor of the witness. So I don't see any problem with gaining access to it or using it. It may be a little difficult to play. I mean, you're going to have to set up the machinery in the courtroom and play back parts of the tape, and that may be a little difficult to accomplish, but I'm sure we'll be able to work that out as the years go on.
Well, what if you only want to like play a certain portion of it, and maybe I'll ask Murray. If Earl only plays a certain part of it, the part that he's interested in, are you then in redirect, even though you've made the decision that you don't want it as part of your direct examination, are you then in redirect entitled to say, well, he's opened the door, I want to play the whole thing now?
Well, I guess the question assumes that it can be played back because the witness isn't behind a screen. But leaving that aside, I think it's much like transcripts, preliminary inquiry transcript where the defense puts a part of it in the trial, and the Crown in re-examination has a limited right to put other parts of the transcript to the witness that reasonably relate to the portions that the defense has put in cross, with a view to, at least in the Crown's eye, to presenting a balanced opportunity to the witness to be related to that particular aspect of the case.
Okay. Nola, before we move off this, let me just ask you about the other, seems to me the other difficult part of 643.1, and if you all look at about the 5th line of the section, it says a videotape made, quote, within a reasonable time after the alleged offense. What does within a reasonable time after the alleged offense mean? And more importantly, are we now back to all the old recent complaint cases that all were abrogated when the code was amended before this amendment?
I think reasonable time is going to have to be looked at, may have to be looked at from a defense point of view in 2 ways. That is, when was the complaint made by the complainant, and then did an extraordinary amount of time elapse before the police or the Crown, whoever is making the tape, got around to making it. So conceivably, as defense counsel, perhaps the complainant notified the police immediately after the offense, but if they, for lack of personnel or whatever, don't get around to making the video for 3 weeks or something like that, that perhaps the defense counsel could argue, well, it hasn't been made within a reasonable time. In other words, the section seems to incorporate the necessity for promptness not only on the part of the complainant to make the complaint, but on the Crown Attorney's office or the police, whoever is going to make the video, to make it promptly. Since there is no guideline within the legislation itself as to reasonable time, I think it's fair to say that perhaps guidance can be obtained from the old recent complaint cases. At least from a defense point of view, those cases interpreted fairly strictly what a reasonable time was. When was the first reasonable opportunity to make the complaint? And if it wasn't made that day or within a couple of days, then usually, in the balance of cases, barring very extreme circumstances, it didn't comply with the rule. So as defense counsel, I would say, well, perhaps we can obtain guidance from those cases, and those cases put quite a high standard, if I might use that word, high standard, that the complaint had to be made quite recently. The trouble with many of the complaints is that they're made years later, and if you have a situation where a person who's now 20 is alleging something about a complaint that took place 10 years ago, and the police very promptly make a videotape of her complaint when she's 20 after she complains, I still don't think you're within this section, because it does say within a reasonable time after the alleged offense, not after the complaint.
Let's move on to another amendment, and if you look back on page I-13, you'll see the new section 442 2.1, and this is the section that Murray mentioned as part of his idea of a defense counsel's bad dream. This problem of witnesses testifying outside presence of the accused. Nola, let me ask you first, is that provision constitutional, or is there an argument that it's not?
Well, I think you can start from the premise that at common law, the common law has developed to the point where it's always been acknowledged that an accused has the right to be present throughout his trial, and that this is based on the idea that the accused always has the right to face his accuser in the eye, and that the person who is making the accusation should have to make it in the presence of the accused. If there is a constitutional argument to attack this, it's probably based in Section 7, that is the right entrenched there in terms of fundamental justice, as well as Section 11D of the Charter, right to a fair and public hearing. I would be, as defense counsel, quite concerned if I was in a position where the accused was seated in court and only able to view the complainant's evidence through a television screen. I think one aspect of the trial is the accused's reaction to the complainant in the stand and the complainant's reaction to the accused in the stand. And the jury, that's part of the assessment in terms of the credibility that goes on, is their observations of the accused and their observations of the witness in relation to the accused. And this section would really deprive the jury of perhaps important information, that is the interplay between the two. The argument on the other side is that, well, the witness may be so young and so intimidated that you're just not going to get any evidence out unless it's done in this anonymous way. But certainly I would have concerns, and I would try to base an argument in Section 7 and 11D.
Murray, what do you think? Is it constitutional?
I think that Nola's point is a good one, that there probably will be shown a breach of Section 7 and possibly Section 11D, but it'll probably boil down to a Section 1 argument, and I have some great confidence that the Crown will be successful applying the Oakes test. As Nola has touched upon, there is a significant reason for this legislation in terms of promoting full and candid disclosure of the evidence, or truth-seeking, in the face of the higher degree of trauma that the courtroom visits on a child. And in my view, that's of sufficient importance to warrant this constitutional infringement. And the Crown would probably be relying on the Queen and Canadian Newspapers Limited, decided in the fall by the Supreme Court of Canada, respecting the mandatory ban on identity of a complainant in a sexual case. I think that case is helpful to the Crown in terms of assessing the proportionality test, because the object, the means are, it could be said, are reasonable and strike a proper test, and there are limiting conditions here. In Canadian newspapers, Mr. Justice Lemaire recognized that with respect to the mandatory identity ban, that there was recognized trauma from trial procedures, to use his language, and I think that ultimately it's going to boil down to Section 1, and the section will be maintained.
It just occurs to me that maybe what we really need as defense counsel is a provision that allows you to put the accused behind a screen. I mean, these guys would come in with a bolt through their nose or something, and a mohawk haircut. It'd be nice to put him behind the screen, deal with the case on sort of abstract principles. Let's move on to Section 16. We've only got a little time left, and you can find that at I-7 of the material. And Murray, maybe I'll ask you this question. Without reading the whole section, in essence, Section 16 allows a child to give unsworn evidence if he or she, quote, promises to tell the truth and is able to communicate the evidence. And what kind of a test does a trial judge apply in deciding whether the child can testify? And is the judge only looking at how old the child is now, or does he look back at how old the child was when she or he is alleged to have witnessed these events?
Well, I think dealing with your second question first, you look at the age of the child at the time of the testimony, and there's a tremendous amount of guidance on all of these issues in the case of the Queen and Con, a decision of the Ontario Court of Appeal under the old legislation, a judgment delivered by Mr. Justice Robbins that is under appeal to the Supreme Court of Canada. And with respect to this issue of the ability to communicate, His Lordship said that guidance could be obtained from old Section 16.1 of the Canada Evidence Act that spoke of child possessed of sufficient intelligence to justify the reception of the evidence. Con was the case where the child was 3 1/2 at the time of the offense and 4 years and 8 months at the time of the testimony. And His Lordship was looking at whether the child's intellectual attainments are such that he or she is capable of understanding the simple form of questions that it can be anticipated will be asked, and is able to communicate the answer in an understandable manner, with the weight to be accorded being left to the trier of fact. And the issue of promising to tell the truth, Mr. Justice Robbins equated it with the wording of old 16.1, saying that there was really no difference. The witness must understand the duty to tell the truth, and in that case there are a whole host of irrelevant considerations which I won't get into. One of them would be the fact that there would be a distinction between a 3-year-old and a 5-year-old's capacity. So I think briefly I'd refer you to that case because it has a lot of the answers to this new legislation.
Let me just give sort of a helpful hint, because I'm not sure that I totally disagree or totally agree with Murray that you're not entitled to look at the age of the child at the time of the offense. If you look at Wigmore and McCormick under competency of witnesses, they, I think, would indicate that if the child was very young and to the point where they really, their perception or their ability to perceive and to remember and so on was doubtful, at common law they would be incompetent. I'm not sure Section 16 has necessarily touched that. In other words, even though the child is now 10, if she was 3 at the time, they may still be incompetent. But you might want to, if you ever are in this situation, you might want to look at it. It may get dealt with in the Supreme Court of Canada because my recollection is the complainant in Con was, 3 1/2 or something, and 4 1/2 when she testified. So that's right on the edge of what would have been allowed at common law to give unsworn testimony. We've only got a couple of minutes left, and we wanted to touch one other area in relation to Section 16. And the other important change that Section 16 has done, of course, and really the revolutionary change, was the removal of the corroboration requirements. You all remember that Section 16.2 and the old 586 of the Code required that a unsworn child had to be corroborated by other testimony. That has been removed. maybe I'll ask Nola first and then Earl to comment. What does the judge do? What kind of a duty is there on the judge now to, in light of the removal of the mandatory corroboration requirement?
I think you can argue that although he doesn't have the mandatory, he doesn't mandatorily have to warn the jury about the lack of corroboration, you can still ask him to charge the jury with respect to the inherent frailties in the evidence of children. At least from a defense counsel point of view, I would ask him to do that, commenting on the traditional comments with regards to their capacity to observe, their capacity to recollect, their capacity to answer or frame their answers intelligently, and that sort of thing. It's obviously not going to the admissibility. The child's evidence has been admitted, but it does go to the weight. And if you've got a situation where your client is testified and it's really boiling down to a matter of credibility between the two, then that particular charge to the jury could be crucial in the case.
Well, Earl, can the judge, are you entitled to instruction that it's unsafe to rely on the unconfirmed evidence of a complainant?
Well, the criminal code's been amended further. Section 274 says as follows: where an accused is charged with an offense under a section that names a number of sexual offense sections, no corroboration is required for a conviction, and the judge shall not instruct the jury that it is unsafe to find the accused guilty in the absence of corroboration. So, I mean, there are going to be cases, obviously, when you have young children testifying in sex cases, and the Crown is going to rely on Section 274, and the defense is going to rely on the common law cases that Nola is referred to with respect to Section 16 of the Canada Evidence Act. I think I mean, it's going to have to obviously be resolved by a higher court, but it seems to me that a judge can get around 274. He doesn't have to use the word unsafe. He doesn't have to use the word corroboration. I think corroboration is definitely a legal term that's grown up over the years since Baskerville, and one might be able to substitute the phrase confirming evidence, which is not as, doesn't require, doesn't have all the strict conditions precedent that corroboration has, and give a charge which is along the lines that Nola says, but perhaps ending with, you may wish to find confirming evidence, but it's not necessary that you do so, provided you're satisfied beyond a reasonable doubt.
Thank you, Earl. That's the end of the time. Let me just, before we move off to the coffee break, just take this time on behalf of myself and Murray and Judge Borins to, first of all, of course, thank you for attending, but also to thank the seminar leaders who have given up their whole day, and as well the people that have written the papers. I think, I apologize that you only got the papers today, but I think once you have the chance to look through them, you'll find them of great assistance. And as well to thank the people at the Law Society, particularly Debbie McGovern, who've really put this program together. So thank you very much. We have a 15-minute so-called health break, and then we're back in the seminars. Same rooms, same seminar leaders.